So our next case file here in the Wexford refrigeration unit is People of the State of Michigan versus David Donald Charles Hill. This is file number 25-14165FH. Appearances, please.
Good morning, Your Honor. Thomas E. Evans, appearing as Special Assistant Attorney General for the State of Michigan.
And I'm Jeff Harrison. I'm here on behalf of Dave Hill. He's next to me at the table.
All right, thank you. You may be seated. All right, we are here today for a final pretrial conference. What are we doing today, Mr. Evans?
Your Honor, I believe Mr. Hill is going to enter a plea under the following terms. As to the charges, the offer is to plead guilty to counts 1 and 2 as a habitual offender, second offense. In exchange for that plea, count 3 will be dismissed and the habitual offender third offense will be dismissed. Under the terms of Killebrew and Briggs, there is a further sentencing agreement. Number 1, dependent on Mr. Hill making his monthly payments up until the time of sentencing. And that is for a 11-month delay of sentence. If during that period of delay, Mr. Hill can reduce the arrears to $17,500 or less, the conviction will enter for 1 count of attempt failure to pay child support, and the habitual offender and original charges will be dismissed. If he's able to reduce the arrears during that period to 0, then 1 count of disorderly person will enter.
Mr. Harrison?
That comports with our understanding of the matter. As I discussed with Mr. Hill, the only thing that I perhaps failed to address with him would be his obligation to pay on his current child support obligation between now and sentencing. But we're willing to accommodate that to the extent possible as well.
Mr. Hill, is that how you wish to resolve today's case? Okay. You swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, nothing but the truth?
Yes.
So you may lawyer. All right. Mr. Hill, you are currently charged on a felony information with 3 counts. Each count is a charge of failure to pay child support. Each count is a felony punishable by up to 4 years and or up to $2,000. Plus, there's a sentencing enhancement called the 4th habitual offender enhancement. That could, within the discretion of the court, increase the maximum punishment from up to 4 years to up to 15 years. That would also have an impact on the sentencing guidelines. I'm told today that you're going to plead guilty to count 1 and count 2, which again are failing to pay child support. Each again are a felony. Each are punishable by up to 4 years and or $2,000. And you'd also be pleading, and then count 3 would be dismissed. And the habitual offender 4th would be dismissed, but you'd be pleading as a second habitual felony offender. Now, the impact of that is, it means that at the time of sentencing, within the discretion of the court, that maximum punishment for counts 1 and 2 could be increased from up to 4 years to up to 6 years, and from up to $2,000 up to $3,000 in fines and or costs. So far, is that what you understood you were doing?
Yes.
Now, if I accept that plea, the other portion of it, there's an agreement between you and the prosecutor as to sentencing. This is called a Killebrew agreement. The Killebrew agreement is just an agreement where you and the prosecutor's office have made a deal And that is, the deal says that I will do something for you at sentencing. And but if I don't go along with it, then you could withdraw your plea and come back to this stage of proceedings and continue negotiating or just go to trial. Now, I have no idea whether or not I'm going to accept it because I don't know you. If I do know you and I have seen you, I apologize, I don't recall. But let's see what we got. The agreement is that you would continue to make your monthly payments. Means from now and until the end of a delay. Now, a delay is, what's going to happen is, right, if I take the plea today and I accept it, we'll set this for sentencing on a Monday morning. Typically in about 4 to 5 weeks from coming from this Monday, upcoming Monday. Then at that time, if I agree, I'm going to place you on a delay of sentence for up to a year. Now, it looks like probation, sounds like probation, and talks like probation, but it's not really probation technically, even though I give you the same terms and conditions that I would for a probationer. They'll be not to violate any criminal law, not to drugs and alcohol testing, if I believe that. I don't know anything about you, but if you had any issues with substance use disorder, I could make that a term or condition. And there'll be other things like continue to pay on your child support. And this delay is for up to 1 year. That means that I generally push these out a little bit to help make sure that you're compliant. Well, after that period of delay, if you've been able to pay the arrears down, which at least at the time of the felony information was $34,840.05. If you reduce that down to $17,500, then you would withdraw your plea to counts 1 and 2, and then you would enter a plea to an added count 4 of attempting to fail to pay child support, which would make that a high court misdemeanor punishable by up to 2 years and or $1,000. Or option 2, if you pay that down from the $34,840 down to 0, don't forget the 5 cents, then you could withdraw your pleas again to count 1 and 2, and then enter a plea to the added count 4 of disorderly person. Now, this disorderly person charge is one of those, it's kind of like a hodgepodge, and it's got 1 in there for failing to care for a child. Anyways, it's a misdemeanor punishable by up to 93 days and or up to $500 in fines and costs. Hold on, did I get that right, Mr. Evans?
Yes, Your Honor. I just noticed a tiny little rumble with the 34, which is the amount contained on the information. Currently, arrears are down to 31,822. So yeah. I thought I'd just pass that.
You understand? All I'm doing is looking at what.
Yeah, I know.
All right, good enough. Thank
That's
you.
what we were just covering too.
I'm glad you guys are. I'm glad you're making those payments. Thank you. So far, Mr. Hill, has what I described to you, is that what you understood to be the terms?
Yes, right.
Good. Now, by entering a plea of guilty today, if I accept that plea, you're not going to have a trial of any kind. Does that make sense?
Yes.
Now, I'm holding up a piece of paper that Mr. Harrison provided to me. At the top, it says advice of rights. At the bottom, it appears to have your signature. Is that your signature?
Yes.
Did you read through these rights before signing?
Yes, I did.
And did you understand what you read?
Yes.
And even more importantly, once again, you understand that if you enter a plea of guilty and I accept that plea, you will be forever waiving these rights as it applies to this particular case.
Yes, sir.
Additionally, you'll be given up the right to claim that the plea was a result of any other promise, threat, or inducement not told to me today. Have there been any other promises, threats, inducements? Are you making this plea of your own free choice?
Yes.
Now, Mr. Harrison's probably talked to you about potential sentencing guidelines, how those apply to felonies, high court misdemeanors, how they don't apply to regular misdemeanors. He's probably trying to give you an idea of possible sentencing outcomes. Is that right? I want to highlight for you first that Michigan sentencing guidelines are not mandatory. They are a valuable tool courts must use, but the actual scoring they give is just really that. It's just a recommendation. So has anyone, so he hasn't promised you any actual sentences? All right, good enough. So has he been able to answer all your questions about the case? Yep. Yes.
Yes.
That's okay. And Are you satisfied with his representation?
Yes, sir.
And you believe that what you're doing today is in your best interest?
Yes.
All right, good. Any questions before I take the plea?
No, sir.
As to counts 1 and 2, failure to pay child support, how do you plead?
Guilty.
And before I go into having you, well, no, I'll do it this way out. That's between 2 date ranges. Count 1 applies to a date range of August 1st of 2021 and February 29th of 2022. And were you ordered to pay child support for children here in Westford County?
Yes.
And was it one child? One. And so for that period of time, you had failed to make those payments?
Yes.
And those payments were ordered by a court that you had to make?
Yes.
For count 2, it covered a date range of April 1st of 2022 through October 31st of 2022. Is it true that you still failed to make those payments of child support and those payments were ordered by a court?
Yes.
All right, thank you. Is it also true that for the second habitual felony enhancement that you were previously convicted of failing to pay child support, looks like back on April 23rd of 2021. Is that correct?
Yes.
Oh, that was here, so it would have been me. I
Yes.
apologize, I don't remember.
It's okay.
But it's always a good thing if I don't remember your name.
Right.
Yeah.
Way better.
Yeah. I say it all the time. If I call the case and use your middle name without reading it, that's a bad sign. But today I had to read it. All right. Mr. Evans, you believe the defendant provided the factual basis?
I do, Your Honor.
Are you aware of any other promises, threats, or inducements, sir?
I am not.
And you believe the court's in compliance with Michigan Law 6.302?
It appears it has, Your Honor.
Great. Mr. Harrison, do you agree with all that?
I do indeed, Your Honor.
So do I. The court finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record satisfies the elements for the offenses. Therefore, the defendant is found guilty of count 1 and count 2 as a second habitual felony offender. Now, Mr. Hill, what will happen again is something that's happened here in the past for you, is we're going to have a pre-sentence investigation report prepared by an agent of the Michigan Department of Corrections. That report will include a description of the offense, description of the pretrial agreement, statements or information you may provide while it's being prepared. It will also include information about prior criminal history and how you've done on bond, probation, parole, any of those things in the past. It will also include a score into the guidelines, which again, I highlight are not mandatory. It will also make a recommendation as to the sentence. Please keep in mind it is merely a recommendation as I make the determinations. And if for some reason I do not go along with this agreement on the sentence portion, you would have the right to withdraw your plea at the next court date. So when you leave here, you're gonna go downstairs to their office, take the elevator all the way down, step out, do a button up to the right, walk in about 10 paces, open the door, don't walk into the door, it'll hurt you, and then walk down the hallway. It's on the second window on the left-hand side. You understand?
Yes.
All right, now. I think I covered it all. Any objection to continuation of bond, Mr. Evans?
No, thank you, Your Honor.
Mr. Hill, your bond conditions still remain in effect. I don't know what they are, but I can look at them, but I know you got them.
I know.
Good. Mr. Harrison, anything further?
Nothing further, Your Honor. Thank you.
We're adjourned.
Thank you, Your Honor. Thank you, counsel.
Thank you.
Thank you, John. Nice.
Yeah.